I'm only 16 and never did anything related to selling. I had an idea similar to satin lined beanies and wanted to, hey, speaking of creators, right? I wanted to create a product for it. Where do I go? How do I go about building a prototype? How would I mass sell it? Is it possible for someone under 16 to create and sell a product, or only for adults at age 18 and up? Lots of questions there. I have so many questions. And someone give me an in-depth answer. Oh my goodness. Lots of places to go there. Do you want to kick us off on this?
So I'm going to find an easy question in there. It's like, can somebody 16 kind of create something? That's not quite what you're asking, I don't think, but the answer to that is absolutely yes. But if I'm 16 and I can only sell it to people who are 18 and over, right? Maybe it's I'm not completely sure about this case, but think about something, a smoking apparatus, like the cigarette holder that's this long, right. Something like that. It's like, it can't be sold to somebody under 18. I think you can still create that. You can still invent that. You might have to work with somebody else to maybe put that through a site or some other location where it's 18 and up, need to be involved, et cetera. But there's really no reason in my mind that you can't be the creator of it. You may run into some struggles when you start getting into contracts and things like that. It kind of depends on where you sign that right. contract, because the age of majority isn't the same everywhere. And you could be asking this question from absolutely anywhere. So as far as like, I've got the idea, I'd like to do this, absolutely correct. But there might be some of those things you need to work through.
Yeah.
What about JD? What about prototypes? Let's just talk about a cigarette holder that you've got a great idea for. Instead of being straight like Penguin did, maybe it goes like this or something. Just as an example, because I'm curious. Come up with something and I want to make a prototype. I can barely make my own TV cabinet that we were just talking about a minute ago.
Yep.
I don't know.
Well, yeah, a few things here. I mean, to me, the age thing is pretty cool. Classic case of, it's true that to be an inventor, you don't need to be an adult. You can be any age to be an inventor named at the patent office. The later questions, I think, go to what you were talking about in terms of how you're going to be able to transact, contracts, having ownership. Ownership may be an interesting question. If you have, certainly you can open up a bank account and you can have access to money. You can likely sell, but you can't really, I don't believe, execute contracts, to be able to list them online, say at Amazon.com, for example, or to engage in legal contracts, you might be limited or reduced. So I think it may be wise to consider bringing on a partner, maybe even a parent or someone who's of age who can work with you and be a part of your business. Set up an entity. It's a common recommendation I make when you're going to be engaging in, even with a third-party prototyper or designer. Usually wise to have a contract in place to maintain confidentiality. And again, you're going to probably want to have someone on your team that's an adult. They can, sign that contract, make sure that's going to be binding and enforceable on anyone who might breach it. But, satin lined beanies, I don't know much about that industry or what you've created, but if you think it is unique and you think there's a big enough market, for these types of beanies, right? This is, I assume, a beanie you wear, satin lined, maybe it's got less friction or, it has a bit of a sleek look. Hats are huge. I mean, maybe there's a big enough market that would warrant investigation to see if it's patentable. And when it comes to apparel, I think about design patents. It's sort of an easy, at least initially, lower investment. But what you have is functional benefit. Like I said, if it has lower friction, if there's some way to actually provide, additional warmth or some benefit utility to the hat, you can for patent protection as well for that. Yeah, lots of questions there, lots of places we could go in further. So we'll stop there for now. How do I figure out if my idea is patentable? This is a great question. So patentability, I usually explain it in terms of two major hurdles to clear. The first one is eligibility. So do you have an invention that is even eligible? Does it even fit in the ballpark of the patent law? And so most things are, most creations, innovations are. Those that are excluded are those that are more natural phenomena, right? Things that are part of nature, DNA itself, right? Equations, right? Laws of physics, things like that will be, not eligible, even though you may have discovered a brand new principle, right? A new understanding of the world or of space, right? That discovery, while fascinating and amazing, is not something you can personally own. So that's what the patent law says. There's also another carve out for abstract ideas, where really there's no tangible way to say, yep, that's what it is, where you can actually point to it and explain where and how it exists, and to where, honestly, you'd be able to enforce it against an infringer. And so those are the areas to talk about with eligibility. So once you clear that hurdle, it's about patentability and whether you can get a patent on it. And there's 3 major criteria for functional utility, and that's you have to be novel, right? First of its kind ever. And that's not just what's been patented before, but what's been published forever and ever. And then the second big one is non-obvious. So even if it's brand new, first of its kind, no one's ever done it before, has there been any motivation or teaching or combination or suggestion that there's a way you could combine previous prior art, previous developments or technologies in the past to create this new invention you've come up with? So if you clear those 2 hurdles and you can prove also that it has a benefit, a utility, you're patentable, and you should probably file immediately. So that's my quick, hopefully not too long explanation on patentability. David, would you offer anything else?
Only just that the non-obviousness of it is one of the trickier things, I feel, when you're trying to evaluate it. It's like, well, I think of a doorknob and they all tend to be shiny, brassy looking, whatever. And I come out of the rain and my hand slips on it. So putting some texture on it, just a little bit of texture to give them just a little bit more grip. That might be non-obvious.
Yeah.
Or that might actually be a little obvious. It's one of these things where sometimes it depends on how you describe it, or when you're looking at something and you're going, I see. I can see how that would be obvious. I can make it a little different. Right? You're the one that came up with it. So if you can go, oh, all right, okay. So we're not going to pursue with that patent, but I know how to change it just a little bit better, a little bit more, and then it is non-obvious, and you can proceed forward. So I'll just throw it out. Recognize that this obviousness concept, as difficult as it is for people who really know what it is to explain, don't just stop there, I guess is what I'm saying, because that's a tricky spot.
Yes, totally. Yeah, I would say work with someone who's got experience. And in those cases where it's close, where you're combining 3 or more, 2 or more pieces of prior art, it may very well be worth to just file. Work with the examiner, work on the claims, and get the claim scope. They've registered a character trademark for shaver shebang, which is a Class 3 cleaner for use on electric shavers. We will soon be launching a new version that we want to call Shaver Shebang Supra. There's an active character mark for Supra, which is Class 3 for liquid soap. Would the addition of the word Supra infringe? So a very specific question here.
It's a very pointed question, and this question calls out, Class 003 is often the way that it's listed, 3 numbers, but a cleaner for electric shavers, liquid soap, just for cleaning things like soap cleaners and stuff like that. These categories tend to be fairly broad, and I'll point out, tend to be non-obvious at times, right? So you kind of need to go and look it up, and there are places, and we can provide links or whatever later, that says, here's what's in this class 003. Oh, okay. And here's specifically what's not in the class, to try and help define what the class is, right? Because you can't just give it a title and go, oh, well, I know what goes in there. It's soap. Well, right. No, it's cleaners, right? Anyway, so you've listed the one class. You've already got a name. I'll just say it's a registered trademark that you have. Go ahead and state that. You're thinking about adding another one, and you're going to add this, right? Kind of like adding another beer. If I'm a brewery, I've got the name of my brewery, and I've got a lager, but I'm going to do an IPA, and it might even be an additive title or something like that. So these are all trademarks. As soon as you've got the second beer, you've got 3 trademarks. So you're in the right spot, and you're asking the right questions. It's a very interesting question because you're saying, I've already got this name, but this other component of the name I'm considering also already exists in the same class for something slightly different. Here's essentially the answer. The trademarks need to be considered in their entirety, right? And you look at a trademark and you've got some words, or it might be a logo or what have you, but the analysis isn't exactly on those words. It's on something called the commercial impression. So what the hell is a commercial impression, David? You're confusing me even more. Well, think about it this way. Think about a bottle of wine called Elephant and another bottle of wine with a picture of an elephant on it. The word and the picture are vastly different things, right? If we hold them together, you go, well, that's this one and this one, they're not the same. Those are clearly different manufacturers of wine, whatever. But that's not how they do the analysis. It's not side by side. It's like I'm looking at this word, and then we're assuming that I tell JD this was great, and he goes to the store and he buys a bottle of wine with an elephant on it, and it's garbage, and then we never talk again, right? So you have to take the whole thing into consideration. So in this case, the first two words and then adding supra. The concern is there's another registration for supra. The question then is going to be, are they different enough? The whole thing is based on confusion. Would a consumer be confused if both of those marks were used in related goods, sufficiently related goods? So then, even though those marks must be considered in their entirety, they can have a primary component. I'll just call it a primary component to that mark, right? So if you add an S and make a mark plural, the primary piece of it is the same, even though they're different marks.
Yep.
Patent versus patents. Those are different, objectively different, but it's kind of a subjective analysis. So they look at, well, what's the primary part? The primary part is patent. And so you end up being denied. So in this case, those words come before supra. Supra is just says, hey, it means like better or first or that kind of thing. It's suggesting that. I would call the primary component shaver shebang, not supra. You might run into trouble if supra is like super famous, like
right.
Gucci. If you said, shebang Gucci, they might go, oh, well, kind of Gucci's the primary piece in the mark you're suggesting, and so it's not going to work. I don't think that's the case here. I would look into it more. Of course, if I was going to actually give you legal advice, which we aren't doing, I would do a little bit more of a deep dive. But just based on what we have in the question and how trademark law works, you're looking at your primary component. You can't really mess up a mark by adding some smaller component that's already registered. So,
okay,
it's a complicated thing. It
yes,
really is.
totally.
But
I think so. It sounds like the answer is
I'm not terribly worried.
Not terribly worried. You should hire counsel to dig into it. It was a great thing for them to sort of stop and ask. So can I be sued for selling a copyright patented product if I purchased it?
Absolutely. I can sue you for any ridiculous reason I want to. The question really is, would that suit be successful or even sustained in court, or just kicked straight the hell out?
Copyrighted, patented, those are different things. Right. I think they're sort of, by putting the slash, they're saying that those are similar. And so there's some confusion there. So copyright, just as a high level, protects works of art that are fixed in a tangible means, something you can touch and feel, held and defined within a fixed manner. So you can look at it, listen to it, look at it all, and it's part of someone's own creation, right? But there's, on the patent side, we just talked about the big three requirements. It has to be unique, novel, non-obvious, and for utility patents, it has to have utility. So two separate things, two separate offices. The Library of Congress will register a copyright, and the United States Patent and Trademark Office will issue patents. So not the same thing. But let's talk about, I'll do patents. You can do this.
Great.
So if you sell a patented product, if it's enforceable, it is an infringement. That is one of the 4 rights you have as a patent holder, is you have the ability to exclude anyone else from making, using, selling, or importing your patented within the claim scope of rights. So even though someone bought a product, they do not have the right to resell or to sell it, make a profit from it. So that's my quick answer for that.
Yeah, absolutely. There are some cases where you can run into just to continue a little bit with patents, like patent exhaustion, right?
Right.
Some Metapart cases and things like that, where it was decided that, well, you bought a product and then you rinsed it and sold it, right? Whatever, right? So it's another space where that can get a little confusing, but there's a similar concept then with copyright. And for a copyright, let's just call it a book. I went to the bookstore, I bought a book. That's a very old thing to say. I went to Amazon, I bought a book. And so now I own that book, that physical copy of that book. Now that's called the first sale doctrine. It's the same thing, really,
Right.
functionally, but it's called the first sale doctrine. That is where the copyright holder's rights end. That's where they terminate. Once I sell you a book, I can buy it. I can sell it to JD. The copyright holder can't keep me from doing that.
Right.
Very near to that is the idea of derivatives. So if I take that book and I kind of make it into something else, and I could spend the rest of the day talking about, well, what do you mean by make it into something else, right? How many John Wick movies are there? So if I took the first John Wick movie and made John Wick 2 myself, that's going to be a derivative work. I'm not allowed to do that. But if I bought a copy of John Wick 1, I can sell that to JD. So I bought it, but because of the first sale doctrine, I can sell my copy. Now I don't have it anymore. JD has it. The copyright holder hasn't lost out on anything. They did sell a copy. They sold a copy of the book or copy, whatever it is. But I can't go and print multiples of them and start selling them to all my friends. That I can't do.
Right. Okay. That's the same for patents too. I think that's what you're saying about exhaustion. Like, if I invented this water bottle, it's patented, and I sell it to you, this one actual water bottle. The one.
That one.
You can actually turn around and sell this for whatever you want.
But I can't go make them anymore and start selling. Right. I can't.
Correct it. And that's why software, you rarely will buy software like Microsoft Outlook, right? It's a license, the EULA, right? The end user license agreement. I think probably for that reason, right? They don't want you to be able to sell it or have whatever rights. They want to be able to keep you paying the subscriptions because you're not actually buying the software.
Yeah, like Microsoft Word. Microsoft Word used to come on a CD. If anybody remembers, a CD. It's not a heart. It's a CD. I could sell JD that CD. Nobody can keep me from selling that CD. I now no longer have that copy of Word. JD has it.
Yeah,
he's over there. JD has it. That works. And for a long time, it wasn't an issue because it all came on physical media, and that's just almost non-existent anymore. So you have to have end user licenses, software as a service. That's just the way. I mean, right now, if you want Word, it's a subscription, right? So they're selling subscriptions to the software. They just kind of changed the way that they provide that to you, and this is largely why.
So is it worth it to get a patent if you cannot afford to sue for infringement? Right. Oh, man. Well, okay. I'm a little biased. Should you get a patent? I think that analysis of whether you take the jump, whether you invest, it could be 20, 30 grand or more. Hiring a professional attorney, law firm to get you a solid patent, develop a patent portfolio, several patents. Is the question is, how big of a market is it? And how much, given the research, hopefully you're doing research and you hire them to do a patent search first, you think, yes, we could get ballpark this much of the market. Is there that much opportunity? Right? Is there enough opportunity there to go capture it? That's the initial question. You really, in my mind, because it can take years to acquire a patent, and because a lot of things can happen in terms of bringing on investors or bringing on a partner and money, right? The ability to sue and to enforce your rights, I think can, and if it's a successful product, will happen. And I think the later conversation, which I'm happy to have you chime in on, is, I would say it's probably 95. Well, I'm not a patent litigator, 95% of controversies. Settle, right? Settle well before they get to costly discovery, litigation, trial, that type of thing. And a lot of posturing. And if done well, even the small guy, small gal can win. Quick final note is I was just celebrating the success this year, I think it was, maybe it was end of last year, the maker within the Apple Watch, the oxygen sensor, fairly small company, and we're still talking $1 million+ company, caused Apple to no longer be able to import the watches through customs, I think for 6 months. So there are remedies other than a suit in federal court through the ITC, the International Trade Commission, to stop infringing articles at the border. So there's other ways to get remedies, right, through injunctions like that, posturing, threatening, getting more money. There's even litigation financing. I'll stop there. David, any comments on that?
When I read a sentence like this, it says, if you can't, I read the last part, the clause first, if you can't sue for infringement. So we'll assume that the first clause is yes, it's worth getting a patent. For all of the other reasons, it might not be worth getting a patent. So the patent is doing the patent, but the question here is, but I can't afford to sue for infringement. Your only other option is to not do it.
Right.
If it's worth doing, go do it. There is a way to afford to sue for infringement, even if it's just a contingency case, right? You can go to probably DLA Piper or anybody, and if you've got a solid case and there's money involved and there's damages, they'll just pick it up. They're going to walk away with 40% of the take, but you find somebody, those pugilists, they're going to go into court and they're going to make that money happen. And now it's not even a question of whether or not you could afford to sue for infringement. It's whether or not you can afford to lose 40% of the damages that are awarded. Yeah, going to court can be expensive, but most of the time, I just don't see that really getting in the way. Go back to whether or not it's worth getting the patent in the first place. But I wouldn't let going to court for something. You can't afford to sue for infringement if you've got a solid case, and the patent is like one of the biggest pieces that makes it a solid case for you.
Beautiful, beautiful.